Okay. Hi, everyone. We're going to go ahead and get started. I am delighted to be your moderator for our final panel of the afternoon on presidential elections and state law. This panel features Professor Vikram Amar, Distinguished Professor of Law at UC Davis School of Law and the former Dean of the Illinois College of Law, Professor Carolyn Shapiro, the founder and co-director of the Institute on the Supreme Court of the United States and professor of law at Chicago-Kent College of Law, and also former Solicitor General of the state of Illinois, and Professor Anthony Michael Kreis of Georgia State University College of Law. I could read their bios to you all day. They're prolific scholars of law and democracy, but instead I think I'm going to let them do the talking. So we're going to go down the line here, starting with Professor Amar, and then at the end I will moderate the Q&A.
Thank you, Miriam, and thank you to all of you for inviting me and for being here today. People have talked a little bit about the Supreme Court in broader terms, so let me vent a little bit about this last term as it relates to some of the things that we're addressing here today. I actually think on balance, the court showed some admirable judgment and restraint in many of the cases it decided. Remember, some of the cases it had to take because the Fifth Circuit is kind of a rogue circuit and was invalidating federal enactments in a way that the Supreme Court couldn't ignore. But this term, unfortunately, is going to be remembered by the two cases that bear Trump's name because of the anchoring effect of Trump versus Anderson, about which I'll talk a little bit more, and then the kind of recency effect of Trump versus United States, the immunity case. So those were just really made up, lawless, kind of poorly reasoned, embarrassing, John Roberts, you want this to be your legacy kind of cases. And so I don't really understand what entirely is going on there. Adam Liptak, one of my classmates in law school, had a piece in the New York Times that I skimmed, and it seemed to me that Roberts didn't want to be irrelevant, so he tried to find a way to be the pivot rather than a sixth or seventh person. And the answer to that is, well, okay, then convince Justice Barrett or Kavanaugh to kind of be more reasonable along with you. That's your job on this court. But let's go to Trump versus Anderson and talk about Roberts at oral argument, because when I listened to the oral argument, I was really astonished. He said at oral argument to the Colorado Council, if Colorado can do this and exclude Donald Trump, then another state could exclude Joe Biden. And states could be doing this tit for tat, and before you know it, the presidential election will come down to just a few states. And he said that. He said that's a daunting consequence, isn't it? I mean, daunting, I suppose, is one adjective, but that is the electoral college that we have. We have an election coming down to not just Wisconsin and the blue wall. It might come down to the blue dot in Nebraska that was mentioned earlier. The idea that every state has to have the same candidates on the ballot is a bizarre concept in the context of the electoral college. Take this, just the rest of this year. Robert Kennedy is going to be on the ballot in Michigan, but not in Virginia. Cornel West is on the ballot in a few places. Just an hour and a half ago, the Supreme Court rejected Jill Stein's effort to be on the ballot in Nevada. So she will not be on the ballot in Nevada, but she's on the ballot in 39 other states that total 421 electors. So there's nothing uniform or nonpartisan about the way states administer presidential elections. And so I was hoping that, that theme wouldn't really account for the opinion. And yet I think it did, because as Mark pointed out, reliance on the fact that Section 5 gives Congress power really doesn't get you very far, because it doesn't explain why states don't also have the power to implement Section 3. Of course, states implement Section 1. Even if Mark's right that we obsess over Section 1, it's nice to have states be able to enforce due process and equal protection, and no one says there's a problem with that. So at the end of the day, it's the last part of the opinion where the per curiam talks about the chaos that would result from the disuniformity that's doing the work. By the way, I think there was one interesting question about disuniformity and potential chaos that was asked by Justice Alito at oral argument, namely, what if Colorado finds, as a matter of fact, through its judicial proceedings, that Trump engaged in conduct that constitutes insurrection? Why, as a matter of non-mutual collateral estoppel, would that not bind Trump from contesting that question when people sue to keep him off the ballot in other states? And the Colorado lawyer gave, I thought, kind of a very underwhelming answer. Colorado doesn't embrace non-mutual collateral estoppel. But what about all the states that do? The real answer is there are exceptions to non-mutual collateral estoppel, just as the United States, under a case called Mendoza, is not subject to non-mutual collateral estoppel. Neither would presidential candidates that compete all over the country and might not have an incentive to fight hard in each and every state where they might not really have a chance of winning that state's electors anyway. So I think there were good answers to Alito's questions, but we never got there because the court careened off onto this disuniformity point. But what bothered me most about the disuniformity rationale in Trump versus Anderson is the court never even flagged, much less answered the question, what if a state wanted to do this under state law? So I start the paper with the hypothetical that in response to Trump versus Anderson, Colorado amends its constitution to say that the people of Colorado shall choose the electors, provided no electors shall be chosen if they are pledged to support a candidate who has been adjudicated as having interfered with the peaceful transfer of power from one administration to the next. And the Colorado Supreme Court excludes the Trump electors from the ballot on that basis. And then it goes to the Supreme Court. And the Colorado Supreme Court says this is an adequate and independent state law ground, has nothing to do with Section 3. What is a court that is even minimally originalist going to do to prevent that from happening? And I think the answer is nothing. That would be, if they were to reject that, it would be unprincipled in a way that makes Trump versus United States or Trump versus Anderson look like child's play. Because all the arguments for why states can't effectively impose qualifications beyond what the Constitution already provides for in the context of presidential elections, all of those arguments are drawn from an entirely separate Article I sphere where elections are constitutionally required. That's the backbone of the term limits case that Lori mentioned earlier. She put up on the screen. All of Stevens's arguments in term limits v. Thornton are about the choice the federal Constitution makes to confer power on the people to pick the members of Congress. And there's a back and forth between whether people refers to each individual voter, as the majority in Stevens seems to suggest, or the people of the state as a whole, the same people who adopted the Arkansas initiative that Justice Thomas and 3 other dissenters, who, by the way, probably speak for a majority today, that the idea that the dissenters in term limits would be in a minority on the court today is probably not true. But there's a dispute about what people means. Is it individual voters, as the court says, or people as a whole? But you don't have that issue when it comes to Article 2, because Article 2 says the state, each state, not any subdivision within the state, not the people of the state, each state shall appoint a group of electors in whatever manner or way the state chooses. And it does use the word legislature, but after Moore versus Harper, about which I've written, I think, more than anyone in the world, unfortunately, I think the legislature and state are pretty much synonymous, notwithstanding some looseness at the end of the Moore opinion. So I don't think the term limits case poses a kind of constraint to states experimenting in this regard and trying to keep insurrectionists off the ballot. And by the way, Trump versus Anderson, as bad as it was, is no hurdle, because Trump versus Anderson was an interpretation of Section 3 of the 14th Amendment. It was no more, no less. It didn't purport to cut back in any way on power that states enjoy under Article 2, Section 1. So the court it was wrong, but in Anderson, the court said Article 3 doesn't confer any power on states to enforce. But nothing in Trump versus Anderson says that Section 3, Section 3 cuts back on any power that states already enjoyed under Article 2. So neither term limits nor Trump versus Anderson is any kind of a limit. Then we have the Anderson versus Celebrezze kind of ballot access cases, which the Supreme Court doesn't seem to stand behind anyway these days. It's kind of a mushy balancing test. And I don't actually, if those cases are right and defensible, they're defensible because they avoid entrenching dominant parties, Republicans and Democrats, over smaller and independent parties. But a law like the one I'm positing that keeps insurrectionists off the ballot has nothing to do with that. It's completely neutral as to party going forward. And so I talk a little bit in the paper about a very similar concept that California adopted in 2019 to require people vying for California's electors to turn over their tax returns. And the California Supreme Court rightly invalidated that on the state constitution, saying that it violated the state constitution to require tax disclosure. And there was a district court in Sacramento that preliminarily enjoined it. But if you read that opinion, it's just really, really bad and thin, I got to say. So I don't think term limits does anything. I don't think Trump versus Anderson does anything. At the end of the day, I don't think the ballot access cases do. And if they do, imagine, tweak my hypothetical. So now I'm not going to have an election of the people. I'm going to say a state gives power to appoint electors to the governor and says the governor shall defer to the wishes of the people as expressed in a popularity poll. Don't call it a vote. Don't call it an election. Except when the people express preference for someone who's an insurrectionist. Again, how on earth you could get around the clear language and history of Article 2, I don't know. And that brings us, before I sit down, to Moore versus Harper. I don't think there's anything in the last part of Moore versus Harper that poses a problem. That's all about distrust of state courts. It's about, I think, unwarranted distrust of state courts. I actually don't think, as we'll talk about more in the schmooze tomorrow for people who attend, I don't think there's a real big risk of the U.S. Supreme Court having a big appetite to use that last part of Moore versus Harper to do a lot of mischief. There hasn't been a single case yet where a federal court, post-Moore, has called into question anything a state court has done in the name of interpreting state statutes or the state constitution. So I don't think there's any constraint in any of this. And so I was just so hoping that a state would have done something after Trump versus Anderson, and maybe in the next election cycle, we'll see more experimentation.
Well, I'll just start by saying it's an absolute pleasure to be here, and my thanks to Dean Dan and to Miriam and Rob and to everybody who has worked so hard, Law Review staff and editors, to put this together. It's great to be here. So I'm going to talk about Trump versus United States, and like Professor Nurse, I don't know what to do with that case as a law professor and who stands up in front of a room and teaches my students about what's supposed to be the law. I actually have ways of talking about lots of cases that I think are wrong, that I think fit into the category of talking about law, and I'm genuinely flummoxed. That would be a polite word, by Trump versus United States. And my focus here is going to be on what I see as its under recognized implications for states and state elections. And I'll start by saying I am thinking this through. I don't have a final proposition other than that I see a problem that is completely unmentioned in Trump versus United States. And I don't think anybody gave any thought to it. So just to quickly summarize Trump versus United States, of course, it arose out of the events of January 6th and some of the lead up to January 6th. It's a federal prosecution of Donald Trump. Donald Trump sought presidential immunity. He said, well, I was president when these things happened, therefore I can't be prosecuted, even though I'm not president anymore. It went to the Supreme Court, and the Supreme Court granted this made up, extraordinarily broad immunity. But I just want to describe it quickly because I think there is undoubtedly some presidential immunity in some contexts. I don't think I think that it's not plausible that there wouldn't be. What the court here said was that, first of all, unofficial acts, there's no immunity for. Everybody agrees with that. There are arguments about how big is the category of unofficial acts, and I think the Supreme Court thinks it's like virtually non-existent. Then there's two categories of official acts. There's official acts that are within the president's core power, things like the pardon power, which is expressed in the Constitution. And for those acts, the president has absolute immunity. Footnote, could he be prosecuted for taking a bribe in exchange for a pardon? The Supreme Court itself appears extraordinarily confused about that. There's a very confusing footnote. And then there's another category of official acts that are more not core, not within the president's conclusive and preclusive power. And for those, maybe he has absolute immunity, maybe it's just presumptive immunity, but I'm not really going to focus on those. He's got a lot of immunity. And the core acts themselves it's extremely broadly defined. It's not just things that are listed in the Constitution, like the pardon power. It's also things like removal power, which is not in the Constitution, but the Supreme Court has concluded is part of his core power. And things like, they say expressly, the take care clause, which is kind of, I don't know what's left actually for there to be non-core things if the take care clause is core. And as a result, and I am getting to states soon, as a result, the Supreme Court said that the president's conversation with the Justice Department about the possibility of there being fraud in states like Georgia in 2020 is a core act for which there is absolute immunity, and for such acts, for determining whether they're official or not, there is no motive is irrelevant. So the fact that he did this for the purpose of corruptly staying in power and did this with the knowledge that he had actually lost the election, those are irrelevant considerations. All right, so what does that have to do with states? Well, think about the prosecution that Georgia has brought against President Trump. He's been indicted along with a bunch of other people for actions in Georgia in 2020. He's also been named as an unindicted co-conspirator in Arizona. I don't think there's any plausible argument that whatever immunity the president has from federal prosecution, he must have the same immunity at the state level. It does not seem that the federal supremacy and our system of government as it's currently constituted could operate if a state could prosecute a president or a former president for doing something that they think maybe violated state law. Vic and I were talking about this earlier, right? What if South Carolina tried to prosecute Lincoln for invading, for sending troops into South Carolina? There are undoubtedly times when the president might do things, or could be times when the president might do things that are well within the president's federal power, and we wouldn't want states to be able to prosecute. The problem is the application of all of this in this context of elections, and in particular in the context of the way the court has historically talked about elections as being so central to state sovereignty. And I actually have, I think in the paper, the same quote that we heard from Quinn about splitting the atom of sovereignty. And the idea that's in opinion after opinion after opinion is that we have these two levels of government because it helps to preserve liberty. Now, I've always been kind of skeptical about this, but that's in all of these opinions. And it comes up especially in opinions related to election law. We have all these opinions where the court says sovereignty, running elections, not just state elections, but running elections generally, but including state elections, is core part of state sovereignty. They get to decide who the people are. They get to decide how the people will vote. And so we see this kind of language in cases like Shelby County, for example, is all about state sovereignty. And when the Supreme Court does this, it's really concerned, and it says so, about federal overreach and protecting this core part of state sovereignty from federal overreach. In some cases, like in Shelby County, it's concerned about protecting the states from congressional overreach. And it's got to stand there in between the congressional desire to interfere with this core sovereign stuff that states do and protect the states. That's what the Supreme Court says it's doing in a case like Shelby County. It also says that, although maybe not always in the same words, when it comes to federal judicial, what it considers overreach. So you might think of Moore versus Harper, actually, as an example of that, but you could also think of some other cases that some of us are less happy with. Rucho for example, I think is an example of that, where the court says, well, you know, states do what they want. It's not for us, the federal courts, to involve ourselves in that. I think we see that in the case of Alexander versus South Carolina Conference of the NAACP from this past term, and also Abbott versus Perez, where they both cases say that federal courts must provide a presumption of good faith in racial gerrymandering cases to the actions of a state legislature. That's about protecting state legislative authority and sovereignty. And this actually goes back, the one case that I assign in constitutional law, it's not in most of the books, is Giles versus Harris, where the Supreme Court says, yeah, we know that in Alabama, there's this constitutional provision that restricts who can vote. And we know that Alabama put that in to stop Black people from voting. But what are we going to do? We can't do anything about it. And this is the key part, it's really up to the people of Alabama. The plaintiffs, the Black people, have to take this up with the people of Alabama, who apparently don't include the Black people of Alabama. So we've seen, the court at that point thinks it would be federal overreach for us to come in and make that kind of, impose a remedy for this violation of the 15th Amendment. So now, though, we have a situation where the executive, I think, has virtually unfettered power to interfere with state elections, with other things too, not just elections, but I think these elections are notable. So for example, if the president wants to send in the troops into Georgia, or the FBI into Georgia, and seize all the ballots on a claim that this is necessary to take care that federal election law be faithfully executed, there would be, the only remedy for that is impeachment. There is nothing else to deter a president as a matter of legal structure from doing that. And when it comes to non-presidential elections, I think the risks are actually greater. At least with January 6th and the run up to January 6th, all eyes in the nation were on what was happening. And there were other national constitutional actors who had a role to play in January 6th, and they did. But if the president were to do what I just described in a congressional election or a senatorial election, or even in a state election, to come in and have the FBI seize all the ballots and say, I'm doing this to take care that the federal law be faithfully executed, I don't think that there would be, there wouldn't be the same kind of institutional checks even that we had with respect to January 6th. There would be less national attention, and impeachment and removal would be even less likely than what we saw with respect to Donald Trump. So as I said, I don't have a conclusion yet. The conclusion may be that we have, there are significant, whether, I don't know that I'm up on board with the Constitutional Convention yet, but there are things that cannot stand, it seems to me, if we want to have be able to resist autocracy. Presidential systems in general are vulnerable to autocracy, so the political scientists tell us, and the Supreme Court has just made it, that our system, that much more vulnerable. So thank you.
All right, I know I'm the last one up for today, so I'll try to be both entertaining and quick. First of all, thank you to everybody here for law review and the faculty who have made this invitation to come talk to y'all today, and for the really just lovely reception. I come to you from a place you may have never heard of. It's called Fulton County, Georgia. Nothing happens of interest, and it's really very sleepy. You know, it's funny because I've lived and breathed the Trump case. In fact, I have been to every single hearing except for one in both Fulton County Superior Court and Federal Court on Trump or Georgia versus Trump, state versus Trump. It's a really fascinating thing to watch, both kind of on a granular level, but also to think about it from a theoretical level. And that's really what I'm going to talk to you today, kind of about the theoretical questions that I think have been raised by this prosecution, potential other future state prosecutions of Donald Trump and his allies. I also come to you in a weird posture because I'm a political scientist at heart. In addition to being a law professor, I study this in this kind of subfield of American politics called American political development. I am a legal realist, but I am going to talk to you about theory today. So that's a little different too. But I think it's important to understand some of the theoretical underpinnings of these state criminal law cases that have been brought, not just the one against Donald Trump, but some of these other ones that have occurred in other states, in Arizona, Michigan, and the like. And there's also potential future prosecutions of Donald Trump, depending on what's going on. And we'll talk about that in a second. So I often think about Reconstruction. That's kind of my bread and butter. That's what I talk about more often than not. And one of the things that always strikes me about Reconstruction is that there was really very little in terms of punishment meted out to ex-Confederates, right? People suffered very few consequences in the long term for their disloyalty, for their treason against the United States. And that's really problematic for a number of reasons. The main reason being that it allowed at some point, and I don't know if you all have ever seen Drunk History, but I got like, it's like I'm doing like 150 years of history in a very short period of time. So forgive me, but it's going to be kind of that variety. But basically, there were just too many, there were too many opportunities for folks to continue to be part of the body politic in their respective former Confederate states, which allowed them to redeem their governments and turn them into authoritarian enclaves. Right, 1870 in Georgia, 1876 in South Carolina. Reconstruction, the promise of it was snuffed out in small part due to the fact that people were allowed to continue to participate in the body politic despite the fact that they were treasonous in their past and never really had never really kind of felt bad about it, right? There was no penalty imposed on them. So I do think it's important to consider, in the light of Reconstruction, in light of that history, that the relationship between democracy and anti-democratic impulses and punishment. Now, of course, federal law does a lot for us in terms of criminalizing conduct that interferes with the kind of administration or the fairness of federal elections. We've got federal law that criminalizes insurrection and rebellion. This goes back to 1862. We of course have these kind of super statutes in our statutory canon that criminalize particular forms of election interference. For example, the Voting Rights Act, right? So if you have somebody engaging in interference that's based on or that's attempting to keep somebody voting on the basis of race, right? We've got federal laws that protect against federal interference or discrimination in federal elections, as well as some for state elections too. We think Section 241, Section 242. There's also provisions in federal law that say, right, you can't try to use federal resources or federal authority to interfere with election or post military personnel outside polling places, right? Lots of that. We also have plenty of state laws that protect against interference or other forms of fraud in state elections. But that raises a question that I think is really important. What do we do about people like Donald Trump or people who may be in the office of the presidency in the future who attempt to engage in an auto coup, right? Keep themselves in power despite losing an election. A lot of people, when the Georgia indictments came down, said, this is a spot for the DOJ. Let the federal government handle this. I think that's fine. I have no problem with Jack Smith's case in DC. I'm all for it. But that doesn't leave the question of, well, why not Georgia? Why can't Georgia, of course, again, biased, why can't Georgia do the same thing Jack Smith is doing? And I think that in large part, there is this important anti-coup principle in American constitutionalism, in American constitutional history, that is a critical dynamic or a critical part of our not just our jurisprudence or our kind of constitutional tradition, but it's baked into our institutions on a state level as well. So I essentially have four reasons why that I think that these kinds of state prosecutions for presidential auto coups are entirely legitimate. The first being that there is a state level constitutional development that embraces an anti-coup principle. That's in my next 4 minutes is what I'll focus most of my time on. Also, the other three reasons, states are the focal point for the right to vote, right? State constitutions have an express right to vote overwhelmingly. There is Republican governance guarantees in state governments, and there's also structural reasons with federalism that have become acutely necessary to consider in the wake of Trump versus the United States. I won't spend too much time on that. I do want to give you kind of the quick and dirty version of some 17th century history, which I think is really important. Too often when we talk about the American Constitution, people love to start in 1775. They love to start in 1776, and I think that's just wrong. We need to start in the early 17th century in England, and I know you're all really excited about this. I would really start with Magna Carta, but then you'd probably leave and I'd have no one to talk to. Let's start with Magna Carta, 1215. There are some principles about, right, the rule of law and kings not being able to be arbitrary in every single way. We get this development of Parliament. That's a long story short. But when we get to King Charles I, the biggest tragedy of King Charles I and really the entire Stuart era in English royal history is that they are not really, they always want more money. Not just want more money, they need more money. The lack of wealth is really kind of the tragedy of this particular house of royalty. But long story short, Charles I believes in the divine right of kings and does everything in his power to avoid basically bringing Parliament in to give the money that he needs to do a variety of things. Eventually, he does, get Parliament in. Again, this is a very too long didn't read version. You got this guy named John Pym. He creates problems, and all of a sudden, Charles is just kind of irritated with Parliament, and at one point sends armed guards, which he, kind of waltzes into Parliament himself with the guards behind him, and tries to arrest these parliamentarians. And it's essentially a coup. Right, he's essentially trying to stage a coup by force, an auto coup in a sense, to reinforce his own power. And you can imagine that doesn't go over well. And we get a couple of civil wars as a consequence. There's a lot more else going on, but there's civil war. Eventually, Charles gets brought to trial, and he says, "I don't recognize the jurisdiction of this court because the king can do no wrong." Well, that argument doesn't really win the day. He loses his head, quite literally. And now we've got a kind of disastrous rule by the parliamentarians. Oliver Cromwell doesn't do a very good job. I'm really brushing through a lot of history. But now we get to an age where the Restoration, because the Cromwellian parliamentarian system doesn't work out so well. So Charles' son gets invited back. And this is where we really get, I think, an interesting dynamic that teaches us something. A couple of things happen, both in the Americas and in England, which I think are really essential for understanding why auto coups are kind of deeply ingrained in our very origins, our very constitutional origins. Essentially, what had happened in part is that King James II had a lot of problems. A good chunk of them were driven by religious animus because he was a Catholic in a Protestant country. But one of the things that he was doing to kind of advance religious toleration and all the rest was manipulating the way in which Parliament was elected so that a critical mass of elected members of Parliament would be favorable to him. Now, this caused a lot of anger in England in the time, right? The king is actually basically undermining the free selection of members of Parliament for his own gain. Now, this is one of the things that really causes a lot of anger in England. There are other things, I'm being very brief in this, but essentially, as a consequence of a variety of different issues, William of Orange is invited. That's a very complicated thing, but he's invited to come over and basically get James II out. James II leaves, technically abdicates, and William of Orange comes in as king, the new King William III. Now, part of this, right, part of the deal in this glorious revolution, as it's called, is that we get an articulation of rights. And one of the rights that is articulated between 1688 and 1689 as a result of this kind of constitutional development in England is that there's a right to free and fair elections. That's really important. At the same time, King James II is very unpopular in the Americas because he is consolidating power it's called the Dominion of New England, but basically consolidating power from New Jersey all the way up into New England and taking all of the colonies which existed as independent entities, right, where there was a right to vote, a right to participate in the democratic governance of the colonies, where there was a sense of the colonies belonged to the people who lived there to some degree. And he consolidated all the governments, and the governor at the time basically dispatched with all of the traditional democratic institutions and the basic democratic culture that was developing in the colonies. Very, very unhappy colonists. When James II is gotten rid of, these colonists are really quite happy because they can revert back to their original charters, which they valued as these kind of, these democratic, these are instruments of democracy. Again, they're not perfect. There are a lot of complications to them, but they're valued, right, as these kind of democratic, instruments. And James II's rule was viewed as, arbitrary and kind of contrary to the values of democracy that were budding in the Americas at the time. America, up until this point, didn't really have any kind of constitutional culture that you could consider to be united anyway, right? There's just a lot of different there's a lot of different governing cultures in the American colonies at this time. It is around 1688, 1689, this period of the Glorious Revolution in England, and at this time where this idea of kind of liberties and rights being attached to the English Constitution and being part of the English Constitution, that the Americas began to develop a more cohesive idea, right? They're all being Anglicanized in a way, a cohesive idea of what it means to be part of this English constitutional system. Now, eventually in 1776, they learn that that folks in England don't see them as part of the system as they thought they were part of. And that's that's part of the whole reason why there's just this great grievance against Great Britain in the lead up to the revolution. But here's the moral of the story that I'll leave with. Part of that settlement of 1688 to 1689 is, again, free and fair elections. Well, what do we see in terms of constitutional development in state constitutions in this period? 8 out of 13 colonies, when they adopt their various iterations of early state constitutions, include free and fair elections clauses in their state constitutions. Not only that, but these state constitutions seem to, right, these are kind of the inheritors of this basic anti-auto coup principle, right? That arbitrary and capricious governance by an executive is just wrong, right? It is contrary to the rule of law. It is contrary to the basic principles of liberty and freedom that should be accorded to persons in this kind of Anglo-American tradition. And I think that that's really important, right? And so, too long didn't read version, and I'll wrap up right now, is for many reasons, right, that I articulated. The fact that there's the right to vote, there's a Republican guarantee clause in the federal constitution that has implications for states. The fact that we have structural dynamics with the electors being selected by state legislatures, or the way that we deal with electors in presidential elections are the responsibility of state electors. The fact that we do need, I think, to address the fact that a president can have a failed auto coup and then try to, as a matter of federal law, just pardon everybody, and then there is no consequence, right? There is no punishment for a failed auto coup in that sense. There's a lot of reasons for why state prosecutions of failed auto coups are important or necessary tools, I think, to have to discourage this kind of unlawful conduct. But I think as a historical and a kind of legal theoretical matter, we have a longstanding tradition, and the tradition of that anti-coup principle was first vested in state constitutions and in state constitutional traditions. And I think that prosecutions like the one in Georgia carry on and really adhere to that tradition in a very important way. Thanks.